and welcome to another episode of Law and Sarasota. I'm your host, Adam Tabrouge, and today I'm very pleased to be joined by Magistrate Susan Maulucci. Thanks so much for being on the program.
Well, thank you for inviting me, Adam.
You know, I always like to start off with my guests and sort of talk about their journey to the law. When you were growing up, did you imagine that you would go on to a career in the law and as a magistrate?
Well, I actually have always been interested in the law. I had a mentor at a very young age in third grade who was a retired judge in my elementary school, and he really did impact my life, and I will credit him with giving me that first taste of the law and understanding of how important it was, and of really igniting my interest, because no one in my family was a lawyer, and no one really went to college before my cousins and I. So I would say that my mentor was really the person that got me interested.
Well, that's a great story, and it really shows the importance that a mentor can play in a young person's life to help guide them on a future career path. Where are you from, and how did you end up in this part of the country?
I'm from Buffalo, New York, and when I graduated from high school, my parents moved to Florida, to Jacksonville, and so I ended up at the University of Florida and went to law school and undergraduate school there.
How did you like law school, and what did you find challenging or rewarding about it?
I loved law school. I loved the University of Florida. I loved the campus and the whole student life there. It was just really exciting and interesting, and it really helped me become an adult in a very safe way, and it really exposed me to a lot there. I really enjoyed my law school days and my undergraduate days too.
And even though I went to Florida State University College of Law, I think one benefit of going to law school in this state is you start to become familiar with the statutes and the case law and the way that the courts work in the state of Florida.
Absolutely. I grew up in New York, and so the law was completely different, much more Byzantine kind of system, and I really enjoyed learning about Florida law and enjoyed my law school time.
And this is sort of relevant to one of the topics we're going to be addressing today, which is non-lawyers in the courtroom and people who represent themselves. And I think one challenge that people underestimate is that the law has its own language, and we really learn how to speak the language of the law while we're in law school.
Well, that's true. I think people think it's very mysterious and difficult. And I think that it can be in some ways, but it can be learned, and people, I think, that are interested in the law can learn about it very easily, and if anyone decides they want to represent themselves in court, there are a lot of avenues to help them do that.
And we'll come back to some of those avenues here in just a moment, but before we do that, I wanted to find out a little bit more about your career path and some of the legal type work you've done since you've been in our community.
Okay. Well, I graduated from law school in 1982 and actually came to this area in 1984. Started as a prosecutor and assistant state attorney, and really enjoyed my time there. Tried quite a number of cases in the 7 years that I worked there. But decided that I really wanted to become more involved in the community, and with one of my workmates started a law practice. Brenda Hiblin and I started a private practice, and I was then in private practice for a few years with Brenda, and then alone until just a few years ago in 2004.
And you mentioned being involved in the community, and I know that you've had quite a bit of involvement over the course of your career. What are some of the activities you've been interested in?
Well, I've always been involved in women's and children's issues, and even when my children were young, I was involved in things, although not to the degree that I am now that they're grown and out of the house, but I've always been involved in that. I practiced in the area of family law and juvenile law, and some guardianship law that related to children. So that was always my interest, and so I've been involved with all kinds of women's legal organizations and just women's organizations in general.
And that's important work. There's areas of the law that are still developing. There's families in crisis in our community that need special attention. And I know you've been a leader in those areas.
Well, I've tried to stay active and involved in things that interested me. In 2007, I became involved with children aging out of foster care, and that was an area that, although I practiced in juvenile law for a number of years before becoming a magistrate, I never really gave a lot of thought to those children and those that aged out of foster care. And so since 2007, we've really created, I think, some good community services for those youth.
Well, you really have. I've been involved with issues of homelessness, and I never realized how much children aging out of foster care contributed to homelessness issues. And it's really important for our whole community to band together and make sure that these young people are not abandoned when they're coming out of that situation.
I totally agree. They're very vulnerable because if they grew up in foster care, everything was done for them. And then all of a sudden they're all excited, they're going to be 18, they're going to be able to make their own decisions, but many are just very ill-equipped to do that. And also they don't have a lot of community support. They haven't really gotten involved with other people that might be able to help them. So they are very vulnerable and really do need the public support.
Well, these days, correct me if I'm wrong, but I don't believe that you have a private law practice any longer. You have another career opportunity that came about some time ago. Let's talk about that.
Okay.
How did you get this appointment as magistrate, and tell us about your day-to-day life?
All right. Well, I became a magistrate in November of 2004. It was something that I was appointed to by then Chief Judge Bob Bennett. It was something that was advertised. I applied for it, and I got the job. And it was for a family law magistrate. And part of the duties of a family law magistrate are to hear cases from pro se litigants. So I do that a day a week, and then other family law matters with lawyers and other miscellaneous things. Sometimes I'd done Baker Act hearings for a period of years and other things, but primarily family law and primarily litigated matters.
So just so our audience understands, what is a magistrate specifically, and under what circumstances might a citizen appear in front of a magistrate?
A magistrate is a quasi-judicial officer, and they get their power to act from the circuit judge. And so magistrates have become used in our circuit in the last 10 years or so to handle things to kind of free up the dockets for the judges. So initially they started doing things like child support and doing some narrowly used, but over time magistrates became used more. So now we do all the pro se litigant cases. We do many other cases with lawyers, many trials, and there's independent living court for the teens who are aging out of foster care, Baker Act hearings, which are mental health hearings, Marchman Act hearings also, which are substance abuse cases. And so magistrates now are a pretty integral part of the system where actual citizens do come in day-to-day contact with us.
Well, I know even just from trying to schedule the program with you that you're really keeping very busy. Can you give us just some idea of the amount of work or the amount of cases that you hear on a regular basis?
Well, every week we hear pro se cases, and it's at least 5 or 10 a week that could take an hour or more. Normally they're cases where people haven't been able to decide their own parenting plan or their own equitable distribution of their assets and liabilities, and we do that in final hearings. We also do a lot of, in addition to all the court work we do, trying cases with lawyers and other kinds of cases, we are very involved in the community. And like today, I was involved with a Law Day presentation with the Bar Association here.
You've mentioned the term pro se litigant a couple of times. Let's be clear, what are we talking about when we mention a pro se litigant?
A pro se litigant is someone who represents themselves in court, and that is not a lawyer, and without any legal training generally.
Now, generally speaking, are there advantages for a pro se litigant to speak with an attorney prior to coming to court on an important family law matter?
I would absolutely say yes. First of all, it's hard to make decisions about your case if you don't know the law, and most people don't realize what they can do themselves to get more information. And even if they do that, I would imagine they wouldn't feel real secure about the information because they're not trained and they're not lawyers. So either for free if they qualify for, with a legal aid program, or for as little as $25 through the Florida Bar Referral Service, they can have an hour with a lawyer and get a consultation and understand a little bit more about their own case, even if they decide not to retain the lawyer.
Does everybody take advantage of those opportunities?
No, I would say not. They don't, and most often people come to court without having prepared. The only thing they've done is filed their pleadings. They have no idea what's going to happen in court.
Well, Magistrate Maulucci, when we come back, what we'll do is we'll talk about some of the things that a pro se litigant could do to strengthen their position when they come into court and to get the knowledge that you've been referring to, so as to make the court process better for everyone involved.
All right.
So please stay tuned for some more Law and Sarasota.
People are discovering an easy way to find their lost pet and help give a loving home to someone who really needs it. With the Sarasota County's Animal Services, adopting a pet can be as easy as scrolling around and finding an animal that seems right for you. Not only does the Sarasota County's Animal Services help to find homes for abandoned pets, they also shelter those who may be lost from their homes. Animal Services takes in any lost pets, so if you have a pet which is run off from home, make Animal Control your first stop and see if they're holding on to your companion. With hurricane season here, bad thunderstorms could frighten your pet, causing them to run off in a panic, or even if they just break through a fence, anything could happen when they would run away. So come on in to Animal Services and check it out. Who knows, you might just find what you're looking for.
Welcome back to Law in Sarasota. I'm your host, Adam Tabrouge, and today I'm with Magistrate Susan Maulucci. Magistrate Maulucci, we were talking about pro se litigants who come into your courtroom, people who are unrepresented by an attorney. And we're going to talk specifically about the issue of divorce for a moment or two. I think sometimes people want to be the first to the courthouse and the first to file divorce papers. But there's a program available in our circuit that may be really useful for people who are unrepresented by attorneys. Could you speak with us about the mediation program?
Yes. Yes, Adam. The 12th Circuit has a pre-filing family mediation program, which is really great for people that haven't yet filed. Once you file, you can't take advantage of it. And so it really is ideal for people that have somewhat amicable relationship with their spouse, where the parties are able to gather whatever information they need to gather, where they're able to then sit down and resolve everything with a mediator. It's totally free, and it's available through the 12th Judicial Circuit.
And how does somebody begin that process? Where would they find out more information about this?
Well, they would call the court administration office at the 12th Circuit in Sarasota or in Manatee County, and they would be connected with the mediation office.
Okay. Now you mentioned, I think, that both parties have to be agreeable in order for a case to go in the mediation process.
Correct. Particularly this program. It requires both parties cooperate and want to go to it. But it's hard for me to understand why they wouldn't want to take advantage of something that could help them. It's free. If they come to an agreement, the mediator is able to write it up for them. They would then have less paperwork that they would need to file when they file their divorce case. And they could handle their matter in a much less contentious way.
Well, let's say that for whatever reason we can't take advantage of this mediation program. Are there steps that a litigant can take before they file papers that might be useful to them?
Well, again, I would recommend that they see a lawyer. They might want to gather some of their financial information. They might want to think about what kind of, if they have children, what kind of time-sharing schedule or what kind of child-related issues they need to resolve. Everybody has a different situation, so they need to know what needs to be resolved, and that takes some thought. And so, I would think that they would want to maybe talk to an attorney if they have any questions about their situation. It's a little bit more complex than people might initially realize.
Well, let's say that I've made my decision and I'm going to go ahead with the dissolution of marriage. We've talked several times about filing. What does that mean, and is there anyone who can assist with some of the forms?
Yes. Well, first of all, if you're not familiar with the forms and you're going to take care of it yourself, you should go to either the 12th Judicial Circuit website and look at the forms. They're all there under family law forms. You can search it, and all the forms are there. They're free. The parenting plans are there. Child support forms are there. All kinds of forms are there, and there are instructions that are included. You can also go to the Supreme Court website. flcourts.org is the website, and you can also get more forms, the forms that I've talked about, plus more forms for all kinds of family law matters there. And again, it's all free, all have instructions, and I would encourage people to read the instructions very carefully before they start filling out the forms.
Now, once I've done what you've suggested and I've reviewed the forms and I've filled them all out, where do I take them?
Well, you'd have to take them to the clerk of the court. There's a filing fee if you can't afford the fee. There's steps you can take to try to be determined to be an indigent litigant, and then you may not have to pay. But it still is a responsibility that you may have to pay back, and you don't want to start filing things that aren't correct. So you should really be very careful before you start filing things to make sure it's the correct form.
What's the next step in the process for the pro se litigant after the papers have been filed, does the case then come before a magistrate such as yourself?
Well, the party who files is called the petitioner. They have to serve the other party, the respondent, and once that's done, a case manager will send them what's called a needs letter, and that will have all kinds of information. It's several pages. People should read that very carefully and follow the recommendations of the letter. And once they have filed all the documents that they need to file, then their case can be either set before a judge or a magistrate, or they can be referred to mediation.
And one reason I wanted to have you on the program today is to talk about things that pro se litigants can do to prepare for court, or things that they should bring with them when they come to court. So what would be your first suggestion or rule for folks who are in that position?
Okay. Well, if they haven't settled their case, if they don't have a marital settlement agreement and a parenting plan, and they expect that the court's going to develop that, they should come to court with their recommendation, what they want the judge to do. And so they should come with a proposed parenting plan. They should have filed a financial affidavit so the court knows what their income is and what their expenses are. They should have all kinds of information if there are items that need to be divided, personal property or real property. They need to come with all the documents. They need to know how much the items are worth. They need to know if they owe money on any of these items. They need to know who they owe the money to. Oftentimes cases have to be continued because people come without that information.
And also, we've mentioned several times the benefits of consulting with an attorney before coming to court, but in some of these areas the laws are constantly changing. The legislature can always tweak or change the law from year to year.
Oh, absolutely. There is always some change in the law almost every single year.
What's some other recommendations that would be good for a pro se litigant to follow coming to court?
Well, I would say that they should come prepared. That is the most important thing. If they can't settle the matter themselves, and they should try to do that, they need to come with all their materials. They need to be prepared. But they really should try to resolve things with their spouse. They should come with a proposed parenting plan if that's at issue, if that's something that's not been decided. And if they think that they might be able to resolve things with mediation, they should ask to be sent to mediation.
You know, we've talked about a parenting plan a couple of times, but just generally speaking, what is a parenting plan?
Well, it used to be that a parenting plan or anything specific, it wasn't required under law, but now it is. The law requires that parents designate the parent who will enroll the children in school. It requires you to come up with some kind of schedule. Not that you always have to follow it. You don't have to follow it if you both agree to change it. But if you can't agree, there's something in place as a backstop. But those are two of the most important things. Other things are communication with the children, with each other, holiday contact. All of those things used to sometimes be very contentious, and now it's required that people have a plan in place that addresses all of those issues.
In addition to parenting plans, what are some of the other issues that frequently arise in these kind of cases that people could prepare for to come to court?
Well, sometimes bankruptcies are involved or homes are in foreclosure. It might not be then appropriate to go forward with the dissolution until some of those issues are resolved. And again, every case is different, and the only way you would know whether or not you should go forward is to consult with an attorney.
I think it's also important for pro se litigants to come in and show proper respect for the court, realize that there's a lot of really important issues that are being decided here, and they want to make sure that they're giving themselves the absolute best opportunity to be heard.
Absolutely, and sometimes people get very frustrated because they don't know what's important to the court, and what's important to the court is what is in the statutes and the laws. And so if they haven't read the statute and they don't know what the requirements are that I have to consider, they're really at a disadvantage. And many people don't realize that it's their burden. If they're asking for something, they have to prove it. And they can't expect someone else to do that for them. They have to come prepared. And they should also come with the documents that they filed so they can refer to them and know what to ask the court for.
You know, I think that that's a really important point, that you're the magistrate in the case. You can't help out one side or the other. You can't be giving legal advice from the bench.
Absolutely, and I think that also adds to people's frustration. They come to court, they think the hardest part of it is filing. But really, as a lawyer, all lawyers know that that's not the hardest part. And there are many hours of preparation that go into getting ready to try a case. It's no different if you're representing yourself.
You know, we've mentioned a couple of places where people can go for help. Is there anything else that we should conclude with?
Well, other things that I think are important that people should think about and remember is that if English is not their first language and they need an interpreter, in most family law cases they have to bring their own interpreter. So that's really important. They also need to understand that what they've seen on TV is not real court, and that is entertainment only, and people need to act like they're in court and provide the information that the court needs to make a decision.
Well, Magistrate Maulucci, I really appreciate you coming on the program and discussing some of these areas where people can get prepared so that they can get the best possible outcome when they come to court.
Well, thank you for having me, Adam.
And thank you for watching another episode of Law and Sarasota.